Is Miss Bunning here? Okay, ma'am, if you can come up to the podium, please. Versus Pamela Bunning. This is file number 255029. The record should reflect today. Mr. Seeger, this is a show cause. I'm assuming that you have not been involved in this file.
I have not.
Okay. So Ms. Bunning, you're before the court here today for arraignment on a alleged probation violation. And the alleged violation is that you failed to make payments towards your court-ordered obligations. Do you understand why you're here today?
I do, Your Honor.
Okay. Ms. Wagner, have you had an opportunity to speak with Ms. Bunning about how we wanted to proceed with this case?
I have not, Your Honor. She's been being supervised in Antrim County. She's been reporting in as instructed. She's been reporting income. She just hasn't paid. She's due for discharge next month. So that's why I put her on the docket with hopes that she'd be able to get moving on her payments.
Okay, so did you just want to proceed with the arraignment today and then have her check in with you?
I do, Your Honor. And I was just going to ask probably, I'm not for sure what her likelihood of getting this paid, but I will have to put in for like at least a 90-day extension.
Okay. All right. So Ms. Bunning, what we would do today, number one, I advise you of all of your rights and then enter a not guilty plea on your behalf. Give you an opportunity to speak with Ms. Wagner, see if we can get this resolved short of, proceeding with any kind of violation. Do you have any questions about that?
No, I mean, I can explain why they're not paid. I mean, I don't know if you guys want to hear that or not, but.
That's something that you can
Okay.
discuss with Ms.
But yeah, no,
Wagner.
I understand 100%. Yeah.
Okay. All right. So first of all, I do want to go through your rights with you just so that you understand. First of all, you do have the right to have a hearing as to whether or not you should be found in violation of your probation. You do have the right to have an attorney present at any subsequent proceedings. We do have Mr. Seeger here today. He's court-appointed counsel. If you had any questions, I'd be willing to stop the hearing and allow you to speak with him. And so if you wanted to do that, please let me know. But you do have the right to have an attorney appointed for you if you can't afford one in this case. If you are found guilty at some point of violating your probation, then it could subject you to the maximum penalty on your underlying charge, which would be up to 4 years. Do you understand all of those things?
Yes, Your Honor.
Okay. Did you want to see if you qualify for a court-appointed attorney at this time?
No, not right now.
Okay. So then I'm gonna enter not guilty plea on your behalf for purposes of today's hearing. The court will set this for a hearing in about 90 days. So that's going to give you that amount of time to speak with Ms. Wagner and see what kind of plan maybe can be worked out. And you'll be notified of the date and time of that hearing, just like you were for the hearing today. But again, that'll be in about 90 days. Between now and then, the court is simply going to issue a personal recognizance bond, so you don't have to pay any money, but you do need to make sure that you continue to comply with all the terms of your probation over the next 90 days. Do you have any questions about that?
No, I don't think so.
Okay. Ms. Wagner, did you want her to stop by here today, or do you want her to make contact with you at some other time?
You can report right now. Thank you.
Okay, so if you just go over to the probation office,
It's right next door.
Yeah.
Okay,
And that's all for this hearing. Thank you.
thank you.
People versus Kenneth McClintock,
Ready, Your Honor.
file number 255125. If I could have both counsel for your appearance. You can go right to the podium, sir. Thank you.
Ryan Seeger on behalf of the people.
Thomas Seeger appearing with and on behalf of Mr. McClintock.
The record should reflect that Mr. McClintock's present here in the courtroom today. Today is the plea cutoff. Mr. Seeger, can you tell me the status of this file?
Your Honor, an investigation was recently done. One of the key witnesses was interviewed by the investigator. I provided that information to the prosecuting attorney's office. In any event, Your Honor, it's my understanding that Mr. McClintock wishes to proceed to trial, so if it's not docketed for trial currently, I would say so.
Okay. Mr. McClintock, is that correct? Is that how you want to?
Yes, sir.
Okay. All right, so we do have this. We did not get a document for trial. Mr. Ziegler, how many days of trial do you think we need for this case? Mr. Seeger?
Likewise, yeah.
And Mr. Ziegler, do you need any particular length of time to be ready for trial?
No, Your Honor.
Mr. Seeger?
No, sir.
I just know I've got several civil trials scheduled, so it's going to be about 60 days for the trial date. So Mr. McClintock, you just need to make sure that you stay in touch with Mr. Seeger. The court will send you notice of the date and time of your trial dates. Counsel, I'll just ask that each of you follow the court's standard pretrial order in terms of providing jury instructions and so forth to the court prior to trial. Otherwise, our next hearing will be the morning of trial. And so Mr. McClintock, you'll need to be here by 8:30 that morning, ready to go, okay?
No problem, sir.
Do you have any questions about that?
No, sir.
Mr. Ziegler, is there anything further we need to address today?
No, Your Honor.
Mr. Seeger?
No, sir.
Okay, so again, Mr. McClintock, just make sure you stay in touch with Mr. Seeger between now and then so you can have him prepare for
No
your trial.
problem, sir.
Okay, thank you. All right, sir, at Wexford County, can you tell me your name, please?
Leslie Massie.
Okay. We're on the record in People versus Leslie Massie. The record should reflect that Mr. Massie is appearing today by video from Wexford County Jail. If I could have counsel put your appearances on.
Thomas Seeger, looking at Mr. Massie.
Mr. Seeger, can you tell me the status of this file today?
Your Honor, this file is confusing only in as much as what the record reveals and what the client had revealed. So originally, Your Honor, the offer was that he could plead under 7411 to one count of possession of methamphetamine, which would be treated under 7411. However, in speaking with the client, it's my understanding that he had revealed that he had a prior use, but when we reviewed lien, it does not appear as though it's on lien. So I'm somewhat conflicted in as much as if he's eligible for 7411, I would want him to have that opportunity. On the other hand, Your Honor, if he's not eligible for it, I don't want to waste a bunch of time because clearly he's incarcerated. And so I guess I would defer to Mr. Massie as to how he wishes to proceed. He can either plead under 7411, and if he's ineligible, the prosecuting attorney would allow him to withdraw that plea at a later date. Or in the alternative, he could simply plead to a possession of narcotics, the 4-year felony, but it would not be treated under 7411.
Okay, Mr. Ziegler, is that a correct statement of the plea offers here?
It is, Your Honor.
Okay. Mr. Massie, were you able to hear that?
Yes, sir.
Do you know how you'd like to proceed today?
Yeah, plead guilty to the charge. Or take the plea of 7411 or however however it works.
Okay. All right, so the way that would work is you would enter a plea today. Is the habitual remaining?
No, the habitual will be dismissed. You'd be entering a plea to count 1.
Okay, so Mr. Massie, under that version of the agreement, you would be pleading guilty to possession of methamphetamine with the idea that you're eligible for 7411 probation.
Yes.
If it turns out that you're not eligible, then you could either allow that plea to stand and go forward with sentencing without that, or you could withdraw your plea and you would regain all the rights that you would lose by pleading guilty today. Do you understand that?
Can you explain that again?
Sure. So today you would be pleading guilty to 1 count of possession of methamphetamine. The prosecutor would drop the habitual offender enhancement and would, if you are eligible for 7411, then that would be part of the plea deal. If you're not eligible, then you could withdraw your plea and go back to the beginning of your case, and you wouldn't have that guilty plea anymore. You would regain all the rights that you would lose today by pleading guilty.
Okay, yeah, that's how I'd like to proceed.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you. You can lower your hand. Mr. Massie, are you currently on any kind of probation or parole?
No, I'm not.
All right, and you understand that by pleading guilty, even with the 7411, the maximum possible penalty for the charge of possession of methamphetamine is up to 10 years and or a $15,000 fine. Do you understand that?
I thought I was pleading to a 4-year.
Nope, if you plead to a 4-year, that's a different deal. In that case, there would be no guarantee of 7411, and you would not be able to withdraw your plea if you plead to the 4-year.
I misunderstood something then, but yes,
Okay, let me just go through it again, just so that we're all clear. So your choices today are option number 1, which we discussed earlier, and that would be to plead to the 10-year possession of methamphetamine with the dismissal of the habitual offender and with the ability to withdraw that plea if you're not eligible for 7411. Option 2 is plead to the 4-year, and whether you're eligible for 7411 or not, you would not be able to withdraw that plea.
Your
Okay.
Honor,
Yep.
sorry to interrupt, but maybe this might clear it up. I was just notified he does have a use of controlled substance on Ross Common, and he was sentenced in October of 2025. So I think that's going to make him ineligible.
Okay, so it sounds like Mr. Massie, I mean, I don't know if you want to advise him on which of those is better.
Mr. Massie, and as we had discussed the other day, you had revealed to me that you had a prior use for which my response was that you're ineligible for 7411 based on your conviction. So when the prosecuting attorney had reviewed your lien, it did not appear as though there was any previous drug convictions. So he was under the belief that you were eligible for 7411. However, now that it's been disclosed by the Department of Corrections that they have information that you're ineligible for 7411, it would be in your best interest to accept a plea to the lesser felony because you're not eligible for 7411 as it is.
Yes, that's what I thought I was doing.
Okay, all right, so again, the charge is,
A 4-year possession of narcotics.
okay. All right, so then Mr. Massie, you would be pleading to the 4-year possession. Is that how you wanted to proceed?
Yes,
Okay, and you want to enter a guilty plea to that charge?
yes, I do, Your Honor.
Okay. I'm going to go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty, and you won't have those rights anymore.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, they have not.
Has anyone promised you anything other than what we've said here in court today?
No,
Is it your own free choice to enter this plea?
it is.
Are you pleading guilty because you are actually guilty of this crime?
Yes, Your Honor.
The information I have indicates that this happened back on October 6th of 2025. Is that the correct date?
I believe so.
On or about that time, were you present here in Kalkaska County?
I was.
And while you were here in Kalkaska County, did you have possession of some methamphetamine?
I did.
Did you know that that's what that substance was?
Yes, Your Honor.
Did you have any legal right to have any amount of it at that time?
No, I did not.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, sir.
Mr. Seeger?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Counsel, are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, sir.
Yes, sir.
Mr. Massie, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of the added count 2. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be contacted by the probation department for a pre-sentence report prior to that, and you'll have a chance to go through that with your attorney prior to the sentencing hearing. Mr. Ziegler, is there anything further to address for today?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Massie, do you have any questions about how we're going to go forward with your case from here?
No. It sounds
Okay.
fine, Dory.
All right, thank you. That's all for this hearing today.
Thank you, Your Honor.
Can I get that tax code?
333-74032A5.
Thank you.
He's
Shall I
here.
say? We have our people.
Yes,
Okay.
Mr.
Holtzbach.
Mr. Holtzbach, yes.
Yeah, you can read them out, please. Thank you.
Thank you.
Mr. Holtzbach, you can come right up to the podium there, please.
Yes, Your Honor.
We'll go on the record in People versus Holtzbach. This is file number 265154. The record should reflect Mr. Holtzbach is present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Seager, with on behalf of Mr. Holston.
Thank you. This is the date and time set for sentencing in this matter. Mr. Holtzbach, did you have a chance to go through the pre-sentence report and talk to your attorney about that?
Gone through it, I haven't talked to my attorney about it.
Do you need some time to do that before we go forward?
No, I don't believe so. I've seen what the recommendation is, it's more than fair,
Okay.
my history. So,
Mr. Seeger,
There are no additions.
challenges to the scoring?
They're not here.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I would simply ask the court to adopt the recommendation. I think it makes sense for a number of reasons, but primarily because of the defendant's history of cutting his tether and absconding clearly make him someone who has repeatedly attempted to obstruct justice. This incident of R&O was not a one-time mistake. The defendant's record of approval, as summarized in his criminal history in the PSI, shows that he has had absconder warrants issued for him 11 times, and 4 of those were for cutting his tether. This is his 10th felony offense. The vast majority of his priors are home invasions or breaking and entering offenses. While I do appreciate that this offense is a step down in severity from his past, lying to police and then attempting to run from police is certainly not what I would call reformed behavior. Given that his guidelines are 7 to 23, I think a 12-month sentence is a fair and reasonable outcome. I would ask the court to adopt it.
Thank you, Mr. Seeger.
Your Honor, on behalf of Mr. Holsbaugh, he recognizes what he's done is wrong. We talked about it quite a few times, and throughout the entirety of it, he's basically expressed that I know that I've done wrong. And so he's accepting responsibility for it. I think he is remorseful if the court reviewed. Clearly, the court has reviewed it, but in his own statement, he's basically admitting that he made a poor choice and that he should have done otherwise. And so he accepts responsibility for what he's done. He's just hopeful that the court will take into consideration that no one's hurt. He's remorseful for what he's done. And whatever sentence the court gives, he's going to accept. He would just ask the court to consider a county time sanction, whether or not 12 months is necessary. He would defer to the court.
All right, thank you, Mr. Holtzbaugh. Was there anything you wanted to say?
Yeah, I'd like to apologize to the officers, you know, I made their job harder that day, you know, than it needed to be. I should have just complied. It's been difficult for me, breaking some bad habits, like, you know, being under the influence, and you know, I was doing well up until prior to that. Still struggling with drug addiction. Found somebody I thought I fell in love with, you know, fall in love with her. Didn't want to be away from her. It was just a stupid decision. I apologize to this court. Sorry.
I did read through the report, so I'm familiar with the facts of what happened here, as well as your background and circumstances based on the information in that report. I don't think I could say it much better than you just did. That's exactly what happened here.
Yeah.
You know, this is a circumstance where there may have been a negative outcome, and that negative outcome got multiplied and made much worse. And it's a road you've been down before. And hopefully, you know, at some point you're going to realize that if you've gotten yourself into a spot, sometimes it's better to just take your medicine and not make it worse.
I know it's been hard, you know. I've been working on changing, you know.
Yeah, and it's hard to change, especially, you know, once you start getting older, get into those habits. But I do think that the recommendation is appropriate. You've indicated that. The prosecutor, I think everybody recognizes that.
Can I?
Sure.
I am trying to go to rehab. I don't know if that's a possibility. I know that funding technically usually runs out the longer you sit in jail. Is there a possibility that the courts would be allow me to go to rehab, and if they don't feel you know, I've served enough, like at a certain point throughout the sentence, I've served enough, let me go to rehab. If you don't, you know, if you don't feel it's still enough, I'll come back and serve the rest. I've completed rehab twice. I had run, first time I did it, but as a parole stipulation, I was ordered to go. The second time I did it on my own. That's how I ended up here in the first place, trying to change everything. I just fell in with a bad crowd and started using again.
Yeah, I mean, I'm always willing to consider that if you can provide some kind of, you know, written documentation from whatever facility you're looking at, that there's a bed ready to go, and the length of the program. I'm always willing to consider that. Okay. So, yeah, I just need to know that there's a bed and that you're not just,
I appreciate that.
Yeah. It's clear based on what I read in the report that you have a substance abuse problem that's contributed to your behavior. So given the nature of this offense, the severity, I don't think a prison sentence is warranted in this case, although as you're aware, your guidelines call for up to 23 months.
I know.
So getting yourself into a position where there's a local jail sentence or treatment is no longer going to be an option for a court. It's just going to be, you're going to head to prison. So I hope you keep that in mind as well. As it is, I think, again, the recommendation is appropriate. I think it accounts for your behavior in this case, as well as your past history. So the court is going to sentence you to 12 months in the Kalkaska County Jail with credit for 97 days served. Crime victims assessment of $130, court cost of $325, attorney fees $300, $68 state costs. Ms. Wagner, I mean, I'm going to assume that Mr. Holtzbaugh has already had DNA testing. Is that fair?
Yes.
Okay, so I'm not going to order the DNA testing fee. You do have the ability to seek an appeal of this sentence. Mr. Seeger, if you could provide Mr. Holtz with his appellate rights. These papers are going to explain to you, sir, how to appeal your sentence if you wanted to try and do that, as well as how to request a court appointed attorney to help you with that.
So $300 like for the attorney, you should be $350. I know it's on the side. It says
Oh, yeah. 350.
Okay.
Yeah. Thank you. I'd like to go forward.
Yeah, I appreciate that. You have a blessed day.
Anybody else?
Is this Mr. Farmer?
It is,
Oh, I'm sorry.
This
Oh,
is
that's Consdorf.
Mr. Cons, Your Honor, and I'm not sure, this is Mr. Consdorf.
Okay, let me just go on the record and file them. We're on the record in People versus Consdorf. This is file number 265148. Mr. Consdorf's present today by video from Waxford. We have both counsel present in the courtroom. I know we inquired into this. It's got on the docket, but it sounds like there isn't currently a motion before the court.
Your Honor, I did not file a motion and it would have been post conviction to leave because he's already been sentenced. So I'm not sure why it got back on the docket unless he filed something unilaterally, which I did not file anything.
Okay. Mr. Ziegler.
I did not file anything, Your Honor, nor have I seen any filings.
Yeah. So, Mr. Consdorf, I think this was placed on the docket by mistake, so we don't really have any business to transact on your file today. Do you have any questions?
No, Your Honor.
Okay, all right, thank you. You're free to disconnect at this time. Thank you.
Thank you.
Okay. Next case is People versus Farmer, file number 255130. Mr. Farmer, if you come forward, please, and if I could have counsel with your appearances on the record.
I am the deputy.
Ms. Seeger appearing with an on behalf of Mr. Farmer.
This is set for a hearing on defendant's motion in limine. I did have a chance to review the motion as well as the response and the supporting documents. You have an oral argument.
Your Honor, I would just largely rely on that.
Likewise, Your Honor, I think my motion.
All right, so, again, in looking at the written submissions of counsel, I think there's two rules of evidence here that are applicable. Number one, for MRE 401, it's relevant evidence. For evidence to be relevant, it has to be material. In other words, it has to go to a fact that's at issue in the case, and then it has to have probative value. And probative value generally means that that fact makes a matter of consequence more or less likely. In this case, what we're dealing with is some evidence that Mr. Farmer may have viewed pornographic materials during the time he was at work. Is that a fair statement of the character of the evidence?
It is, Your Honor.
Okay. And so the question is that probative on the ultimate charge, which is this is criminal sexual conduct involving a disabled individual.
Yes, sir.
So and I believe it is this 4th degree?
It's 4th degree, Your Honor.
So sexual touching. And touching of breasts, is that right? That's being alleged? Okay. So does the fact that Mr. Farmer, if true, if he did in fact view pornographic materials while at work, does that make it more or less probable that he engaged in a sexual touching of one of the residents of the home that he was working at? And so in looking at that, one of the things that stuck out to me was actually a fact pointed out by the prosecution, which in my view actually hurts their argument, and that is that a statistic that 91% of men view pornography. And so to me, if it's that prevalent, if that number of individuals are viewing pornography, then to me that reduces the probative value of the fact that Mr. Farmer happened to be looking at it. Because if viewing pornography makes it more or less likely that you're going to improperly touch another individual, and 91% of men are doing it. I just don't think you can make that correlation. It's that common. Clearly, 90% of men are not engaging in improper touching of sexual touching of other individuals. So the fact that Mr. Farmer happened to view it, if true, again, doesn't necessarily mean it's more likely or less likely that he touched the individual improperly that he's alleged to have touched. We do have kind of the added factor here that he's allegedly viewing this while at work. But again, I think he could easily view it at home, and that would arguably give him just as much motivation to touch somebody as viewing it at work would. So I don't think that that additional fact also makes it more likely that he engaged in criminal sexual conduct in this case. So I don't find that there's that logical probative connection between the viewing of pornography, even if it was at work, and the alleged criminal sexual conduct in this case. So I don't find that it's relevant under a 401, even if it is arguably relevant under 401. I think under a 403 analysis, because of the lack of probative value, I think it's more likely to lead to a confusion of the issues, or more importantly, I think the chance that the jury is going to give undue weight to the fact that he was viewing pornography when there really isn't, again, any, I don't think, logical connection between looking at pornography and engaging in a criminal sexual conduct crime. Again, if it's true that 91% of people are looking at it. So for all of those reasons, I find that the evidence should be excluded under both 401 and under 403. So the court will grant the defendant's motion, and Mr. Seeger, if you could prepare an order reflecting the report.
Yeah.
Mr. Seeger, was there anything else we needed to address on Mr. Farmer's case?
No, Your Honor.
Mr. Ziegler?
Okay.
Okay, thank you. That's all for this.
Your Honor, there was a request, and I did speak with the prosecuting attorney. He didn't have a particular objection to the extent that the court is willing to amend his bond where he's not required to do viewing screens any longer.
I don't have any objection to that.
Okay, Mr. Seeger, if you could prepare a stipulation in order, and the court will sign that.
That's fine. Thank you, Your Honor.
Thank you.
You're all set.
Our next hearing set for 9:45. We'll take a short recess until that time. go on record that people versus. File number 5510, the record should be second, 17 and 14 today.
I'll have somebody back, Mr. Donald.
This is the date and time set for sentencing in this matter. Mr. Donald, did you have a chance to go through the pre-sentence report and talk to your attorney about that?
Yes, sir.
Mr. Travis, I know there's a challenge to the scoring by the prosecutor. We'll address that in a second, but in terms of the body of the report, are there any additions, solutions, or directions?
I don't believe so, Your Honor.
Outside of OB 14, do you have any challenges to the scoring?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
And I did review your memo regarding OB 14 as well as your response, Mr. Travis. Is there anything you wanted to state in support of that, Mr. Ziegler?
Your Honor, just that I think even if you look at the last incident where drugs were brought up, it's quite clear that Mr. Donald was a leader in that circumstance. He made the arrangements, he gave directions to Mr. Bland. But when you look at the totality of the circumstances where there were 2 buys before that, where Mr. Donald was making the arrangements to come up here and sell out of an alleged drug house, where he was with a different person for each of those transactions, it's clear that he had some leadership role, at least with relation to Mr. Bland or other persons who were driving with him for these deliveries. So I would ask that we support it.
Thank you, Mr. Travis.
Basically, the crux of my response is I definitely understand Mr. Donald had the most evidence against him, but I don't agree that that draws a conclusion that he's a leader. As I indicated, I would actually say almost on the inverse, that if there was a leader, the leader wouldn't be exposing themselves to the most culpability. We don't know. Nobody made statements about this. Nobody was interviewed about this. I understand what the prosecutor's saying, but I would, that's an assumption made by the prosecution to the benefit of that scoring, when, as I noted, just as likely the assumption could be the opposite. And in many senses, at a broader criminal vision, that's how criminal activities happen. The people at the bottom, the people who are most exposed are the people at the bottom, the people most exposed. Thank you.
All right, I did review the pre-sentence report. In order to justify the scoring of any particular variable, the court has to find that there are facts which would support that scoring by a preponderance of the evidence, more likely than not. The court can use information contained within pre-sentence reports, police reports, sworn testimony, and so forth as a factual basis when looking at the scoring of a variable. OV 14 deals with the offender's role, and it's properly scored at 10 points when the defendant is a leader in a multiple offender situation. And in this case, I mean, I would agree with you, Mr. Travis. I don't think there's any direct evidence. You know, there's no testimony or direct statement saying Mr. Donald is the one who was directing all these activities and the leader of these activities. I also agree with Mr. Ziegler in that when you look at the totality of the circumstances here, I think there's sufficient circumstantial evidence, especially under a preponderance standard, where one could infer that it's more likely than not that Mr. Donald was the leader, in that there were a number of buys. Mr. Donald was always involved in arranging those buys. They involved significant amounts of methamphetamine, and they were done on multiple occasions with multiple different people. And so I think based on that evidence, it does support a scoring of 10 points. And so the court will grant the people's challenge and will score OV 14 at 10, which raises the total points for OVs to 15, raises the OV level to 2, and takes the guidelines from 0 to 18 to 12 to 20. Mr. Ziegler, is that a correct adjustment?
It is, Your Honor.
Mr. Travis?
Yes, Your Honor.
Okay. Do you have any other challenges to the scoring, Mr. Ziegler?
I do not.
Anything on behalf of the people for allocution today?
Your Honor, I largely support the structure of the recommendation that's contained in the report, with a term of upfront jail followed by some probation, While Mr. Donald is young and he has no record, he was bringing large quantities of meth into our community and into the surrounding communities as well. Mr. Donald was charged in Otsego County for delivering to an undercover there at the same time. Mr. Donald appears to have good family support. He appears to recognize that his behavior was a mistake. However, it is important both for Mr. Donald in particular and for others who may be considering engaging in similar behavior of bringing drugs into our community that this sentence have some punitive component. Court sentence can be focused on rehabilitating Mr. Donald while also discouraging him and others from engaging in this type of behavior with a jail or prison sanction. I think that given his lack of record and given the new guidelines, Your Honor, a jail sanction of 12 months and a 2-year probation term is a reasonable punishment. And so I would ask the court to do that.
Thank you, Mr. Travis.
Thank you, Your Honor. I appreciate the recommendations and the recommendation for probation. I would ask the court to still follow that. As noted, Mr. Donald is a young man, and he's, as much as he made some very grave mistakes, he has handled this very well. He's always understood that he was going to take accountability for this. He's here with his mother and siblings for almost every hearing. So I do think this is someone who can definitely come out the other side of this and do quite well in life. He stepped in it very deeply here. Some of that, it can't blame it. It wasn't an entrapment case, but there was a lot of enthusiasm between both sides. Pretty much all of this that we have, he's actually interacting with TNT officers and agents, and they, you know, he thought he was going to make a bunch of money, easy money, and they were, you know, encouraging that, if you will. Not that it was their plan for them to do it or anything of that nature, but there was an enthusiasm, like a youthful, delusional enthusiasm that this was going to just be kind of simple and easy and quick money. He learned that's not the case. There's no quick money here. There's no easy here. This is pretty bad, and you know there's going to be consequences for it. And he's understood that from the first time I met him. So I would ask Your Honor to keep him in the county and put him on probation, because I do think he would do quite well. He's done great on bond. He has very strong family support. He, in general, has a strong base. Was doing decent, you know, good in school. No criminal history, no juvenile history. Thank you, Your Honor.
Mr. Donald, anything that you wanted to say today?
I'm sorry, Your Honor. I know the severity of my charges. I'm ready to take full responsibility for them.
Okay. Mr. Donald, I did read through the report, so I'm familiar with the facts that happen here. I'm also familiar with you and your background and your circumstances based on the information in that report. And I think your attorney's done a good job of pointing out mitigating factors or the factors that warrant a lesser sentence in this case. You are a young man. There's lots of time for you to reform and change your behavior and not engage in this kind of behavior anymore. And again, in the future, that's something that I think is important to consider. You don't have any prior history. I think that's also something that's important to consider. Those are all things that work in your favor in terms of what the sentence should be. There are also some things that don't work in your favor. The amount of methamphetamine that you were bringing into this community, to me, is a little shocking. When I look at the amounts here and the weights listed in this report, I see lots of methamphetamine cases, and very rarely do I see a case where someone has brought as much methamphetamine into this community as you did. And in my view, that warrants a harsher sentence, not only to punish your conduct, but as the prosecutor indicated, to act as a deterrent both to you and to others, that this is something that we cannot tolerate, we cannot allow. as your attorney indicated, even though you're young and you don't have a prior record, you sure jumped in with both feet right into the deep end of this with this amounts of methamphetamine that you were bringing in. And so I think that's a problem, and that it occurred over multiple different buys. You know, you had an opportunity over the course of this to say, this isn't right, I shouldn't be doing this, and to stop doing it. And you continue to do that. And I think you're going to have to make a decision as you go forward, whether making quick, easy money is worth what you're doing to other people to make that money. I don't know if you've ever seen individuals that are addicted to methamphetamine, but it is a devastating condition. It ruins people's lives, it ruins their health, it turns them from productive human beings into people that basically are on the verge of death. And so you're going to have to decide whether you want to make money off of that, and whether you want to be part of harming other people like that to make an income. And that's a decision you're going to have to make going forward here. But bringing these kind of amounts of methamphetamine and helping other people get that to destroy their lives, I don't think is a way that you want to make your living in life. I hope not. Taking all of those things into consideration and recognizing that even under the old guidelines, the court could sentence you to up to 18 months in prison. I think your youth and the prospect that you can move on from this and not engage in this conduct and be rehabilitated indicates to me that at this point a prison sentence is not warranted. However, for the reasons I stated, I do think a lengthy jail sentence is warranted along with probation. So the court is going to follow the recommendation to the extent that I am going to order that you be placed on probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order that you serve 12 months in the Kalkaska County Jail. You do have credit for 7 days served. The court is going to order restitution in the amount of $950. It's payable to the Kalkaska County Clerk to be dispersed to Michigan State Police. Crime victims assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. You'll also be required to pay a supervision fee while you're on probation of $30 per month. You do have the ability to seek an appeal of the sentence. Mr. Travis, if you can provide Mr. This appellate rights, please. Mr. Dano, you are remanded to the custody of the county at this time.
One question, please. When does that restitution have to be paid? Is that going to, upon his review?
During the time of his probation, so over the next 2 years, yeah.
Okay, thank you.
Your Honor, I have one question. Is that a full 12 months in the county jail?
Yes, sir. No, you just need to go with the officers now.
I love you.
I love y'all.
I love you too.
I'm gonna call you.
Mr. Travis is. Mr. Matt, is Miss Massie?
I just stuck my head out. I do not see her out there.
Let's go on the record in People versus Massie. This is file number 255145. If I could have counsel put your appearance down.
Ryan Ziegler, on behalf of People, Your Honor.
Kyle Travis on behalf of Ms. Massie. All right, I spoke to Ms. Massie last week. I did not call her this morning yet. I'm not sure what's going on. I know she doesn't drive. She's usually, her daughter has brought her to, I think, every court appearance I've been to. I can go try and call her. Give me a moment.
Do we have Miss Ferguson?
We do. Yes.
He is, they're bringing him up right now.
Okay. Miss Ferguson, right? Leah Ferguson?
Yes.
Okay. So let's take Miss Ferguson's case and then you want to check on Miss Massie. All that.
Thank you.
Like you said, they're bringing her up.
Yeah. That's why I just wanted to make sure if you said him.
Yeah.
And, I want to make sure we're talking about the same
Yeah.
person.
Still on the same page.
Still know Miss Ferguson? Still know Miss Ferguson?
No, not yet.
I just talked to Mrs. Massey's daughter there.
And what?
They're like pulling in the parking lot.
Christie, I could see me sliding off the edge.
Switch those chairs. It's dangerous.
It's over there right now.
At least it's not on camera. See me on YouTube. On court cam. Which I've seen you on court cam. You ready for it?
Yeah.
Okay.
Oh. Wow.
Okay, Ms. Ferguson, if you can go right up to the podium over there. Yeah. And we'll go on the record in People versus Leah Ferguson. This is file number 265159. The record should reflect Ms. Ferguson's presence here in the courtroom today. Ms. Ferguson, did you have a chance to talk to Mr. Travis and go through the pre-sentence report with him?
Yes, I did.
Mr. Travis, are there any additions, deletions, or corrections to that report?
Not that I'm aware of.
Are there any challenges to, oh, I'm sorry, this is a misdemeanor, so there's no guidelines. Mr. Ziegler, do people have any additions, deletions? Do you have any victims that wish to address the court today? Anything on behalf of the people for allocation?
Your Honor, I would largely ask the court to adopt the recommendations. It's a misdemeanor plea involved taking a cell phone. That cell phone was recovered and returned to the victim. The defendant's already served 81 days on this misdemeanor offense. The court believes that more is required. I think there's there's certainly a basis to do so, given her lengthy criminal record. But I'm satisfied with the 81 days she's already served, so I would ask the court to simply adopt the recommendations.
Thank you, Mr. Travis.
Thank you, Your Honor. Similarly, we would ask the court to adopt the recommendations. I would know, we don't know what's going to happen, but the matter in that Seago has still not been dealt with, so she may still be
Has
facing.
been.
It has been?
I went into Zio and I had it over Zoom on Thursday.
What was the result?
30 days in for 30 days, or they ran it concurrent.
Okay. We have an update, Your Honor.
Okay.
The Seago matter has been resolved. I don't know that the Grand Rapids matters, I don't believe those have been resolved, but they are fairly minor. I imagine they will just need an appearance to be taken care of. But we would still ask the court to adopt the recommendation.
Ms. Ferguson, anything you wanted to say today?
I'm sorry to family. And I will never, ever do it again because I'm tired of being behind bars.
Yeah, I mean, I read through the facts here, so I'm familiar with what happened. It just seems like something that could be avoided. Yeah. Taking that person's phone and then trying to claim that you found it in the bathroom. I mean, just for somebody at your age with your history, it's time to move on from this, I think. It's not a particularly serious crime, but one that I think does warrant some degree of punishment. You've already served 81 days. I think given the nature of the crime here, I think that's an adequate punishment. And so I am going to follow the recommendation and not impose any additional jail time over and above that. And then the court is going to impose fines and costs. And I think that, again, adequately addresses your conduct in this case and your past history. So the court is going to sentence you to 81 days in the Kalkaska County Jail. You do have credit for 81 days served. The court is going to order a crime victim's assessment of $75, court costs of $325, attorney fees of $50, DNA testing of $60, and a $53 state cost. This is a misdemeanor, so you won't receive any written appellate rights. However, you do have the ability to seek an appeal of the sentence. If you wanted to do that, you would need to file for your appeal within the next 21 days. If you have more questions about that, Mr. Travis would be able to answer any questions you might have if you want to appeal of the sentence. Otherwise, the court will sign the judgment today and shortly. Yep, you're going to need to contact the clerk's office here to make arrangements to pay those fines and costs.
Can I get that number?
I don't have to do that.
It's 231-258-3349.
Mr. Ziegler, there's no request for restitution.
No, Your Honor, the phone was recovered.
Thank you. Okay, Ms. Ferguson, that's all for today. Good luck to you going forward.
Thank you.
Clerk, can you tell me your name, please?
I'm not here for this.
You're not, okay.
Just passing review or present report.
All right, People versus Massie, file number 255145. The record should reflect Ms. Massie's presence here in the courtroom today. I could have counsel put your appearances up.
Ryan Ziegler, yeah.
Travis, on behalf of Mrs. Massie, Your Honor.
Thank you. This is the date and time set for sentencing in this matter. Ms. Massie, did you go through the pre-sentence report with your attorney?
Oh, yeah, yeah.
Okay. You did over the phone with them?
Literally, yeah.
Okay. Mr. Travis, are there any additions, deletions, or corrections to that report?
No, Your Honor.
And Mr. Ziegler, do the people have any additions, deletions, or corrections?
No,
Anything on behalf of the people for allocution?
Your Honor, Ms. Massey's before the court for a 1-year misdemeanor. Presumptively, this is a fines and costs case. However, I think given her history and given that this case involved possession of narcotics, a jail or a probationary sentence could be justified by the court. Ms. Massie has apparently had a long history with mental health. Use of controlled substances has not helped that situation at all. I feel like the PSI author is probably correct, given that she's been on probation multiple times before and we're still back here. Further probation is probably not the best use of county resources at this time. So therefore, I would simply ask the court to adopt the recommendation, sentence Ms. Massie to a short term of jail with no probation.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, Ms. Massey, I don't know how far back it goes. The report indicates even maybe back to a previous marriage, things probably weren't going that great. In interacting with her and representing her on this case, she has struggled quite a bit to leave her house. I know at certain instances, her daughter, who's here in support of her, and his brother, I think pretty much every court hearing, has struggled to even get her to get in the car. After her husband, who is currently incarcerated, was out of the house, it seems like things kind of descended. Even worse, I don't know that they were in the best of shape, given the situation that was kind of going on there. But Ms. Massie is you know, I'm not trying to allege she's not competent, but she's struggled with her emotions, with her mental health, and just in general. I don't know that incarceration is obviously maybe a reasonable response, but I don't know that it's going to benefit her at all and improve the situation. She is on a bit of a improvement. Her daughter has been able to start to try and step in and try and help her more and get involved, but she doesn't. When I talk to her, she gets Social Security disability as noted in the report. She has no idea where the money is. She doesn't know where the bank is. We talk about, well, we would need to call the bank. I talked to her again, none of that's ever happened. She's just struggling quite a bit. So I would ask the court to either consider this a fines and costs or maybe a brief probation, but I think her needs are almost beyond probation. She really needs just to be tapped into CMH, I think, pretty heavily. She needs more social work than anything else. Because she, I think, could get back on her feet. She's appropriate in talking to me about things. She understands these things. She just struggles to move forward dealing with them. Because I think there's just so much going on that it's hard to find where to start digging. And it's easy to just get overwhelmed and kind of give up. So I know she hasn't done amazing on bond. She is indicating that she has tested clean recently. A lot of bond issues, which I understand probation would say, hey, we don't want her to come in as just a lack of finances and a lack of transportation, more than I think that she's been using or anything during the course of this. So as much as I understand that the probation agent felt that 3 months would be a reasonable answer to this, I would ask Your Honor to consider finding costs, and if you did feel that jail time was required, to consider a substantial amount less, because I don't know that she will, and I know that's not the court's only consideration, but I don't know that she will come out of jail any better than she went in. Thank you, Your Honor.
Ms. Massie, is there anything you wanted to say today?
I don't want to go to jail. I'm clean right now.
She's gonna continue to stay clean and booted, just do fines and costs and things like that. I've been working with her really hard. I've been getting her house cleaned up. She's got nobody from her past and whatever was going on prior to this has been involved in her life at all. I basically put the foot down and I got her here.
What's your name, ma'am?
Katie Miller.
Katie Miller, and your relationship to Miss Miller?
Daughter.
Your daughter? Oh. Biological daughter, stepdaughter? Okay. All right, well, so there's a number of ways that the court can punish wrongful behavior. Jail is one of them, and financial penalties is one. And I read the report in this case very carefully, and I thought about your case, Miss Massie, quite a bit in terms of what is a solution here. And I don't think it's with jail time. I don't think that's going to do the community any good. Any of the purposes that I would typically order jail time for, I don't think are going to be accomplished in your case. And so I'm not going to order jail time. I'm going to order fines and costs. The only thing that I think the facts here justify it as well, just because I don't think, based on your history, your prior issues with substances, what happened in this particular case, I don't get the sense that you were a leader in this. I get the sense that you were kind of along for the ride and using. So I don't think there's any public safety concerns here to be gained by putting you in jail. Given your history and your current conditions, your mental health struggles, I don't think it would serve the interest of punishment. You know, I don't think, certainly it's going to be an unpleasant experience for you, but I don't think you are going to gain anything in terms of modifying your future behavior through punishment. And I don't think this is the type of crime that needs to be an example where there would be a deterrent effect. And so, again, I think this is the type of situation where financial penalties are adequate to address the conduct. I would say, Ms. Miller, you know, I don't know your mom other than a few times I've seen her in court and what I've read in the report. You know, her capabilities much better than I do, but she does appear to me as somebody who needs help. And to the extent you're willing to do that or able to do that, I think that would go a long way towards keeping her out of trouble.
Absolutely.
Because she may get herself involved in something where a court doesn't really even have the discretion at that point. Jail, you know, is gonna wind up, and I just don't think that's the right place for her. I agree with Mr. Travis. I think social work and some mental health treatment is really gonna go much further towards helping prevent that. I don't think probation's appropriate for that, just because I think that would be setting her up for failure to have criminal penalties for failure to comply. And I think this is a situation where really it does fall on family to help if you're willing and able to do that.
I am absolutely.
For all those reasons, I don't think probation is appropriate either. So I am going to order that, ma'am, that you pay a crime victims assessment of $75, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $53 state cost. The court is not going to impose any jail time. Or actually, Miss Wagner, I don't know, did you author this report? No, it doesn't look. Did you? I'm not sure.
I did not, but what do you need?
Well, one part indicates 0 days credit, one part indicates 2 days. Do you know, Mr. Travis?
Oh, she's got 2 days.
Okay. So the court will impose 2 days of jail with credit for 2 days served. And Ms. Massie, good luck to you going forward, and Ms. Miller, good luck to you as well.
Thank you, Your Honor.
Deputy, can you check with Mr. Horowitz and see if he's ready with one of his clients?
He's
Oh,
talking
he's
with,
back there.
with Mr. McElroy back there.
Let's see if he's ready.
You ready with him?
Good show.
Yes, I'm ready with Mr. McElroy.
Okay,
Do that.
we can bring him forward. All right, you can go right up to the podium there, please. And this is file number 255128. Reflect Mr. McElroy's present here in the courtroom today. If I could have counsel put your appearances on.
Michael Horowitz on behalf of Mr. McElroy.
Thank you. This is the date and time set for sentencing this matter. Mr. McElroy, did you have a chance to go through the pre-sentence report with your attorney?
Yes, we did.
Mr. Horowitz, are there any additions, deletions, or corrections to that report?
Not really. The only thing is, as to the time calculation of 153 days, I don't know if that needs to be updated for today or if that was as of before. And I know that Mr. McElroy's time calculation is probably.
It looks like it's calculated through today, so, and we don't count the date of sentencing. So 153 days is correct?
I honestly, I can't verify it just because of the times that Mr. McElroy has been in and out. He's had another case, and like I said, it's been complicated. So I don't think we're going to object to the 153 days.
The only thing that, like, I don't know if Mr. Ziegler remembers that we talked about August 6th last time we were here, and you said yes, but I don't know if that's correct or not. That would be my time on this sentence.
I don't know about that.
You remember?
I don't have a record of that, Your Honor. It looks like he wasn't arraigned until November 5th. So I don't know how it could go back to August, but if there's some factual evidence to support that, you can supplement the record later.
Yeah, I mean, I guess Mr. Horowitz, to the extent that Mr. McElroy has an argument for more credit, I would certainly entertain that as part of a post-judgment motion.
We can look into it. Thank you.
Okay. Are there any other additions, deletions, or corrections?
No, Your Honor. Thank you.
Do you have any challenges to the scoring of the guidelines?
No, Your Honor. Thank you.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges by the people?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, I would support the recommendation contained in the report. This is Mr. McElroy's first felony conviction. He's already served 153 days with guidelines of 0 to 11. I think the recommendation of jail sentence followed by a probation term is a fair outcome for this case. In my view, a sentence in the middle of the guidelines range of 0 to 11 is probably an appropriate outcome. I don't think his conduct warrants a sentence at the higher end. It was a simple possession, but I think his record indicates that a sentence at the lower end is probably not warranted either. I would leave it to the discretion of the court whether 5 months is a sufficient amount of time or whether more is needed. But I would otherwise ask the court to simply adopt the recommendations.
Thank you, Mr. Horowitz.
I think that's a reasonable argument from Mr. Ziegler, Your Honor. You know, Mr. McElroy was charged and convicted based on possession of, I believe, residue of a personal amount. So there's no allegations of greater conduct out there. This isn't a pleaded down distribution case or anything like that. This is somebody that's suffering from addiction and using as part of addiction. He was not doing anything untoward at the time. He was riding a bike down the street, but somebody recognized him as
having a warrant. I guess we can say that's untoward, not remaining yourself on the warrant or something. That said, I do think that this conduct falls at the lower end of the spectrum. I think that's reflected in the guidelines. The only thing that really would set this apart from a normal first time possession case is Mr. McElroy's record, which is substantial. And I think that the court can adequately consider that based on the guidelines being scored for his criminal history. Yeah. Oh, also, I need to point out, he is in red today. Red does indicate that Mr. McElroy has recently been made a trustee at the Wexford County Jail, which is new. That's something that reflects his conduct while in custody, and that he's been, following the rules and doing what's required with him. So to the extent that that's been a change, that speaks well to his credit. And I think that echoes the pre-sentence report's thought that maybe this time probation will be able to help Mr. McElroy, based on his own words, do what he needs to do. So thank you.
Mr. McElroy, anything you wanted to say? Yeah.
Very early, got 3 kids out there that need their dad in their life. And this is, hopefully means to an end for my life. I'll move forward with my life.
What's your view of probation here?
I think that I'd be able to do it with flying colors. I'm 43, I'm not 17 no more. I've got 3 children that I have to set an example for. And I mean, if I can't do it, well, I can even say for them, have that argument with my wife going up or whatever. I have to set the example. I have to be the lead for them so that they don't wind up where I'm at.
All right, well, I did read through the report. I do know, I think Mr. Horowitz pointed this out too, none of your guidelines are based on any of the offense variables. Your OBs are 0 here, which tells me, this is a relatively benign offense. You weren't selling, you weren't distributing. This was a personal use amount. You weren't engaged in any kind of assaultive conduct. It doesn't appear that there was any resisting or any issues with police. So, we're left with your past history, and the more you continue to be involved in these types of charges, the higher your guidelines are going to get, and you're eventually going to wind up in a place where you're headed to prison. It sounds like, based on what you're telling me here today, that that's not the direction you want to go in, and I hope that it's not. The other consequence here that I highlighted in the report was that the residue on the foil tested positive for heroin and fentanyl. And you probably know better than anybody else in this room that that's a mixture that can kill you. And you take a dose that's got a little too much fentanyl in it, and that's it. Kids don't have a father anymore. And it's not even a matter of probation or jail. You're just gone, and you're never coming back. That's the scary thing about this, because you never know what that dose has in it when you take it until it's too late. So I hope that you would use this. I'm going to order probation, and I hope that you do use it to get some resources available to you through probation. And I hope that you take advantage of that to prevent that worst possible outcome. So the court is going, and I agree with Mr. Ziegler that a sentence in the middle of the guidelines is appropriate. So number 1, the court's going to place you on probation for a period of 18 months. The court is going to adopt as the conditions of your probation all the terms and conditions listed in this report. The court is going to order that you serve 6 months in the Kalkaska County Jail with credit for 153 days served. Crime victims assessment of $130. Court costs of $325. Attorney fees of $350. DNA testing fee of $60, $68 state cost, and supervision fee while you're on probation of $30 per month. You do have the ability to seek an appeal of this sentence, and Mr. Horowitz, if you could have Mr. McElroy.
Your Honor,
Yes.
I just wanted to let you know, I went back and confirmed the jail credit. 153 days is correct. He did come in August 12th, but that was for an FOC matter, and this case was not even authorized until November 5th.
Okay, thank you.
And then can he report to me, since I believe he's going to be getting out of jail today, if he can report to my office today?
I think he's got a little, well, I don't know what with jail, with his good time where he's at, but he's got 153 and I ordered 180 days. So.
Your Honor, Mr. McElroy has signed the advice of appellate rights indicating that he has received it.
Okay, thank you. Good luck to you going forward, Mr. McElroy.
Okay, so it now she wants to become.
Correct, yes.
Report to. These are yours. With you.
Terry.
Thank you.
Yeah, Mr. Barkovich, is he in Department of Corrections?
Not here.
Oh, let's call that case People versus Scott Barkovich. This is file number 265151.
I say he's not, but I did not discuss these status today. He was out. I'm not aware of anything that he would be being held on.
Okay. So for the record, this matter was set for hearing at 10:30. It's now 10:50 by my clock. 10:45 by the courtroom. Have you had any contact with Mr. Barkovich?
I believe I had contact with Mr. Barkovich. This is an order to show cause hearing, is correct? I believe that I had contact with him shortly after the last hearing that he failed to appear at. And that he explained that he was not able to get to court that day. The phone number that he had, I think, was somebody else's. There were a couple different numbers being used, but they weren't good for return calls. But I believe that that was my last contact with him.
So I do know for the record that he failed to appear at the hearing back on March 3rd. Well past the time of hearing, he's failed to appear today. Mr. Ziegler, the court would ask that you prepare a bench warrant, and we'll proceed with Mr. Barkovich's case first. Further, once he's arrested and brought before the court. Yes, sir. Looks like you have one more case, Mr. Horowitz, but not till 11 o'clock.
Not till 11, and that is going to be a challenge, Your Honor, because I needed to speak with him briefly, but he's not going to be here. He's in another jail.
Okay. This is People versus Burroughs, file number 265164. Do you know where he's lodged?
I believe he's in Charlotte, Kalkaska.
Mr. Ziegler, do you have any information on that?
Looks like he was in Charlevoix, at least for the last hearing on February 23rd, 2026. We did not prepare a writ for today, so I don't know if it's complicated, Your Honor, because that was the last day the secretary was here. We've since hired a new secretary, but it's possible that that got lost in the shuffle and we were supposed to prepare a writ, did not. But I don't have any current information as to his whereabouts.
Okay, so I'll reset this for another hearing. And Mr. Ziegler, I'll just request that you prepare a writ for Mr. Burroughs. Yes. Do you have any objection to that, Mr.
Oh, not at all. And I'll stick around in case he's not in there. He shows up.
Okay, thank you. Are we ready on Mr. Evans' case? Counsel? We're a little early, but if you're ready, I can take the case now.
We're hoping to steal a few minutes of Mr. Ziegler's time before we go on the record.
That's fine. I mean, we're ahead of schedule, so I don't mind. All right, so let's take a brief recess.
Should I stay here?
Yeah, sir, if you want to, thank you. We'll go on the record now. This is People versus Evans, file number 234811. Record should reflect Mr. Evans is present in court today. If I could have counsel put your appearances in.
Your Honor, Ryan Ziegler, yeah.
Good morning, Honor. Solomon Radner substituting in as counsel on behalf of Mr. Evans.
All right, thank you. We're on the record today for a status conference in this case. The record should reflect I did have a discussion with both counsel and chambers prior to the hearing today to discuss how to go forward. So Mr. Radner, I'd like to make a record of how we want to proceed.
Your Honor, at this time, we're asking for a 30-day adjournment so that Mr. Ziegler and I can discuss potential resolution, as well as clear up a couple of evidentiary things that we just want to both look into. We'll know within 30 days how we want to proceed, and we can come back in 30 days and hopefully at that time either have the case wrapped up and resolved or otherwise advise the court on what the next steps are going to be.
Thank you, Mr. Ziegler.
Yeah, we did get the Supreme Court denying the defense application for you to appeal about a month ago. Mr. Radner just appeared on this matter within the last few days. I didn't know until yesterday, this morning, he was appearing. So we have a few things that we need to discuss. I don't have an objection to an additional 30-day adjournment.
Mr. Evans, you've had an opportunity to speak with your attorney about this.
Yes, sir.
Is that how you'd like to proceed as well?
If that's what he recommends, yes, sir.
Okay. All right, thank you. So the court will reset this for a hearing in about 30 days. And we'll proceed at that time. Mr. Radner, anything further we need to place on the record today?
The only other thing is, depending on what date it's going to be in 30 days, there are some days that my calendar is more clear than others. Does this court ever allow lawyers to appear by way of Zoom? And
Yes.
just so we're clear, okay.
Yep, as long as you submit something in writing at least 7 days prior to.
Okay, I don't plan on doing that. I never appear in a court unless I'm willing to be there.
Sure.
But if that becomes necessary, I will do that. Thank you.
And I would say, I mean, particularly if there is going to be a plea that day, might be difficult to do if you're not here in person and your client is. So,
right.
Okay. Mr. Ziegler, anything further from your side? Okay. All right, thank you. That's all for the record on this case today.
Thank you, Alan.
Thank you. One final case for this morning. And it's a PPO matter, Mr. Ziegler.
Okay.
Not something that-
I think I heard
And Judge, we did go past 11 and Mr. Burrows did not show up, so I suspect he's still.
I suspect he wasn't printed. He's probably still in Charlotte. We'll confirm.
Okay, great. There you can see who we have on tip versus tip out in the hallway.